के देवता भगवान श्री कृष्ण के चरणों में मेरा नमन। परात पर गुरु डॉक्टर जैन बालाजी आठवाले के चरणों में मेरा नमन। एंड a very namaskaram and good morning to all of you. And I am really grateful and thankful to Shefali Tai as well as Jagan ji for calling me here second time in this Western Ghats Literature Festival and giving me this opportunity to interact with all of you. So basically the area which I am going to focus today is certain developments which have happened in Gyanvyapi case, Kashi Vishnath case, that I am going to bring to your knowledge. Apart from that, the development which has happened in Bhoshala case, in Mathura Shri Krishna Janmabhoomi case, certain other areas where our temples have been acquired, those areas I'll be highlighting. And apart from that, certain constitutional issues which need our attention also will be a focus point of my presentation today before you. So first of all, because we are meeting after a year, so a lot of developments have happened so far as Gyanvyapi case is concerned, and two which I believe the major developments in Gyanvyapi case, Kashi Vishnath case, which have brought us very close to victory, are the reports of ASI as well as the Darshan Puja which has started in the premises in question. So I'll put this two things in perspective for all of you. Let me tell you that last time when I was meeting all of you and we were discussing these issues, we had done a lot of research based intellectual exercise so far as the Shastrik Mahatva of Gyanvyapi Kashi Vishnath is concerned, so far as the legal history and legal litigation which has happened in Gyanvyapi and Kashi Vishnath is concerned, and the area of survey commissioner where advocate commissioner had gone there in the premises in question and had found Shivling and various other parts of Hindu signs and symbols were found from Gyanvyapi in the premises in question. All these were the developments which had happened. Apart from that, certain other developments happened in this gap of 1 year, which are like very important thing which happened is that, as you all know, that on 16th of May 2022 we had found Shivlingam in the so-called Gyanvyapi mosque, the alleged Gyanvyapi mosque, and that Shivlingam area in the Vazu tank was sealed on 16th May 2022 itself by the Honorable Civil Court of Varanasi, and that order was upheld by the Honorable Supreme Court. So the first thing which we asked for was survey of ASI survey of the Shivlingam area, and ASI had also given a report of 52 pages saying that at a prima facie glance, at a cursory glance, this Shivlingam looks very ancient, looks very old, looks millions of years old, and it requires an investigation. The Honorable Allahabad High Court on 12th of May 2023 passed an order directing for ASI investigation of the Shivlingam. The matter was challenged by Anjuman Intizamiya in the Supreme Court, and on 19th of May 2023, the Honorable Supreme Court stayed the order of the High Court. So the fact of the matter is, and today the case which exists is that the Shivlingam which was found, which one party calls as fountain, could not be investigated by the ASI. Now the second demand which we made before the District Court of Varanasi was that all right, the Shivlingam area has been stayed by the Supreme Court by order of 19th of May. So the other remaining part of the so-called mosque, alleged Gyanvyapi mosque, must be surveyed by the ASI. This demand was accepted by the District Judge of Varanasi on 21st of July 2023, and a detailed order was passed for digging, for excavation, for survey by GPR through modern technologies. And when this order was passed on 21st of July 2023, this order was carried out, implemented by the central government, and on 24th of July 2023, a 42-member expert team of the ASI reached the spot at 7 a.m. in the morning, and they started conducting the survey. It is at that point of time Anjuman Intizamiya reached the Honorable Supreme Court by way of a oral mentioning, and they said that this survey must be stayed. The Honorable Supreme Court stayed the survey for 2 days, that is till 26th of July 2023, and directed the Anjuman Intizamiya to file their petition before the Allahabad High Court. The fact of the matter is that the Anjuman Intizamiya filed their petition before the Allahabad High Court challenging this survey order passed by the Honorable District Judge. On 25th, 26th and 27th of July, 3 days the matter was heard by the Honorable Allahabad High Court by the Chief Justice of the Honorable Allahabad High Court. Judgment was reserved, and on 3rd of August, the Honorable Allahabad High Court pronounced the judgment upholding the order of the District Judge where the direction of survey was given. But let me tell you, there was one undertaking which was given by the ASI, and it became the part of the order of the court also, that they will not do any excavation, they will not do any digging. So in this survey, the report which has come, without digging, without excavation, non-invasive methods have been adopted by ASI in doing this survey. And this order of 3rd of August of the Allahabad High Court was challenged by the Anjuman Intizamiya before the Supreme Court, and the Supreme Court also upheld the order of the Allahabad High Court on 4th of August, the very next day. So after the directions of the three courts, in 15 days, from 21st July till 4th of August, from three courts we had got this order of ASI survey. And when this survey happened for 90 days in the Gyanvyapi premises, ample number of proofs and documents and research which goes and shows and proves to the hilt that there was a pre-existing temple was found from the premises in question. Various scriptures which relate to Hindu temples, Hindu structures were found from the premises in question. A detailed epigraphic study was conducted by the ASI, wherein the ASI found that there was a very important finding which has been given by the ASI is that there was a pre-existing structure which was of a Hindu temple, and on that basis only this so-called mosque has been built over. This was precisely the question in Ram Mandir case, which the presidential reference was given to the Supreme Court to ask, and the presidential reference was that whether Ram temple has been built over after demolishing a mosque. At that time the Supreme Court did not answer that question, but here the beauty of this case is, and the distinguishing feature of this case is, that ASI has given a very, very categorical opinion that this place is built upon a Hindu temple, a pre-existing Hindu structure. And a very important point is that during this survey, the ASI had found an inscription from the mosque itself. That inscription was broken. It was into two pieces. But the fortunate part is that ASI had the original photograph of that inscription. And a theory was given, and all of you would have heard that theory, that this monument, the so-called Gyanvyapi mosque, is prior to Aurangzeb. And it was, and you are finding so many Hindu signs and symbols there because it was built at the reign of Akbar. And Akbar had floated a secular religion called Deen-e-Ilahi. So therefore there were signs and symbols of all the religions. So we found an inscription from the mosque itself which said that this structure, the so-called Gyanvyapi mosque, has been built during the time of Aurangzeb itself. It was found from the mosque itself. Half broken piece of the inscription was found, and the original photograph is with the ASI. So all these things are part of the report of the ASI. So very categorical ASI report has come, which makes our case very, very strong so far as legal issues are concerned, and so far as the issue of factual ascertaining of the situation is concerned. And the beauty of this report is that this report has been given by the ASI even without digging, even without excavation, just through non-invasive methods. Now, the next very important development which happened in Gyanvyapi case is that, as we all know, that right opposite Nandi, I'm talking about the Nandi which is there in the new temple complex which was built by Rani Ahilya Bai Holkar in 1770. Right opposite that Nandi, there is a, we actually call it in a colloquial term as Taikhana, but actually it's on a ground floor. It's a room on the ground floor of the alleged mosque, right opposite Nandi. In that room, the history of that room is very interesting, that from past 500 years, the Vyas Parivar, which is known as the family of priest, the traditional priest of Kashi, used to sit there in that room, and they used to do various worship, puja and etc., bhog prasad, everything. In November, December 1992, 1993, in that era, the Mulayam Singh Yadav government, in violation of the Places of Worship Act, had thrown away Vyas Parivar from the so-called Taikhana or so-called room which exists on the ground floor, and the worship which was happening in that premises traditionally was stopped by a particular government. And let me tell you, it was in utter violation of Places of Worship Act also. Places of Worship Act was enacted in July 1991, and the mandate was to have a status quo. Despite the mandate of an act, the Vyas family was thrown out from the premises in question, and the worship was stopped. And in that Taikhana, in that room on the ground floor, two locks were put. One key was with the Vyas family, and the other key was with the district administration of Varanasi. Now it so happened during survey, and it's a great example for all the seculars of this country who had argued in Sabrimala that why women should not enter temple, and various arguments were raised. Here you will be shocked to know that despite orders from three courts, from District Court of Varanasi, from High Court and from Supreme Court, the specific direction was that the plaintiffs, who are the women plaintiffs in this case, have to participate in the survey. Despite this direction, the women plaintiffs were not allowed to enter the so-called mosque, despite the directions of the court. And the argument was that we do not allow women to enter into the mosque, even if you are doing your official duty, even if it is the order of the court, we will not allow you to enter the mosque. Now, why I am saying all these things is very important, because it so happened that one of our female colleagues and senior advocates had come to visit the premises in question, and when she tried to enter the so-called Taikhana, the ground floor which I am talking about, the Taikhana of Vyas Parivar, there was heavy resistance by Anjuman Intizamiya, and it came to light at that point of time that the doors of this Taikhana, which I told you that there were two locks, one key was with the district magistrate, and the other key was with the Vyas family, the door was also broken. And Anjuman Intizamiya was claiming that this Taikhana, this ground floor room, belongs to them, and it is within their control. It is within their premises, and no one can enter this room. And therefore, the entrance of senior counsel was also stopped by Anjuman Intizamiya and heavily resisted. It is at that point of time it came to our light that since the doors of this Taikhana have been broken, and we don't know from when it has been broken, at any point of time illegal possession of Anjuman Intizamiya can happen in this premises in question. So kindly just connect the chain of events. The Taikhana, the ground floor room, was in the possession of Vyas family from past 500 years, which is time immemorial, you can say. It was stopped in November, December 1992, 1993. From November, December 92, 93, the possession continued till 2023, and suddenly the doors were broken, and Anjuman Intizamiya was claiming possession over that room. Now that room is very significant, because that room which I am talking about has huge signs and symbols of Hindu temple. During commission survey also, we had found a lot of Sanskrit shlokas. The pillars of that rooms are of Hindu temple, and lot of signs and symbols. The entire structure itself shows that it's of a Hindu temple. So we moved a petition before the District Court of Varanasi, and we said that in the premises in question, the district magistrate of Varanasi should be the receiver, and immediately district magistrate should be appointed as the receiver, because at any point of time Anjuman Intizamiya can take illegal possession of this so-called room. The Honorable District Court of Varanasi on 23rd of January 2024 passed a direction directing the district magistrate to immediately take over the possession of this Tehkhana and appointed him as the receiver. And the next prayer was that please direct the Kashi Vishwanath Trust to start puja in the so-called premises in question, in the so-called room, the puja which was continuing and which has been illegally stopped by a particular government. I am very happy to share with you this information that after detailed research and after following all the due provisions of law, the District Court of Varanasi, after hearing Anjuman Intizamiya on 31st of January 2024, directed the Kashi Vishwanath Trust to start puja in the premises in question within 7 days. And on the same day, at about 12 p.m. or about 1 p.m., the Uttar Pradesh government, in compliance of the orders of the District Court of Varanasi, started the puja in the premises in question. So a big achievement in Kashi Vishwanath case is that from January 2024 till this day, when I'm interacting with all of you, puja in Gyan Vyapi premises, which was known as Gyan Vyapi mosque premises, in the ground floor of the so-called mosque is started, and 5 times puja is happening there in the Gyan Vyapi premises. The puja which was happening colloquially. So for next 4 months at least, there was no appointment of district judge in Varanasi. So many people ask me this question कि case slow हो गया है, case में कोई progress नहीं हो रहा है. So the fact of the matter is that there are certain things which were beyond our control. Because we can do research, we can argue in the court, we can put our points across, we can inform all of you. But appointment of district judge is not within our hands. And district judge itself was not appointed for 4 months. In June, the courts went for vacations. And from July, the district judge and the district court of Varanasi is giving dates on every Saturday. And not much development is happening so far as this issue is concerned. And therefore, it is very, very important for all of us, because I am saying this with lot of sense of responsibility, as well as the research which I have done in the case, that we have come very close to victory in Gyan Vyapi case. Very close. It's a matter of time. But what is required and what is very important is that we have to build it as a movement. We have to think about it, we have to strategize. And legally, I'm not asking for anything which is beyond the purview of law. Legally, we all should sit, we all should make it as a demand, and we all should talk about it. Gyan Vyapi and Kashi Vishwanath has not been spoken from past 10 months. We have spoken about various other issues. But this is the core Sanatan issue. The person who has installed Sengol in the parliament, if we want to bring Dharmaraj, if we want to bring Hindu Rashtra, if we want to bring Ram Rajya, if we want to bring spiritual Rashtra, it is very important that Kashi Vishwanath is liberated. That's the beginning of this country. When Kashi Vishwanath will be liberated, it will be the establishment of Dharmaraj in this country. It is very, very important. It is not just a temple. It is not just a dispute of a particular piece of land. It's an issue of a civilization. It's an issue of our survival. And the last wish of Chhatrapati Shivaji Maharaj was to liberate Kashi. It was his last wish. So we are fortunate that we are living in an era where we have seen in front of our eyes liberation of Ram Mandir. And on 22nd of January, we all had seen how Ram Mandir, Bhavya Ram Mandir was inaugurated. We all have to unite together and talk about Gyan Vyapi and ask questions that why Gyan Vyapi case is not being heard, why dates are given on every Saturday, why the case is being delayed, why not fast track trial is happening in this case, why not the matter should be transferred to the Allahabad High Court for fast track trial. These are the questions which we have to ask as a civilization. It's not a time to sit quiet. It's not a time to ask questions to your advocate that, sir, what is happening in the case? You must also take initiative. That's why I'm today in front of you. Generally, as a lawyer, our work is to argue in the court and then finish, and it's end of the matter. Why I'm here before you is that this is not just a case of Vishnu Shankar Jain. This is a case of the entire community. This is the case of entire civilization. And whatever judgment in Gyanvyapi will come, it will impact, it will hamper all our interest. And therefore, the delay which is happening in this case is hampering our interest, because so far as research work is concerned, we are very close. And the judgment which has, the Shivlingam area which has been stayed by the Honorable Supreme Court, that needs to be vacated. So far as legal exercise is concerned, we are doing that legal exercise. But as a community, as a civilization, why I am giving this information to you is that we have to come forward, we have to come and make a common demand that this case must, what we all need today, in Gyanvyapi, in Sri Krishna Janmabhoomi, and all these civilizational battles which were going on, our case on research, and I'm telling you as a lawyer, that our case on research on merits is very, very strong. What we just need from this entire system is, we need a fast track trial. If this matter is decided by the court within 6 months or 1 year, our legal team is totally ready on evidence, on spiritual evidence, on legal history, everything, that we can narrate the case to the Honorable Court and a decision can come. Let me tell you that in Ram Mandir case, the Honorable Supreme Court, before some time, had given a statement, and I will not quote the Honorable Judge, that this is not an important matter for us. The entire country united, and they demanded that this matter must be decided. From 2nd August 2019, the hearing in Ram Mandir case started. 42 days continuous hearing happened in Ram Mandir case, and the judgment was delivered on 9th of November 2019. So in this manner, we have to unite as a community, and we have to demand from our court that please decide this matter at the earliest. There is no point of delaying this matter any further. The report of the ASI is in front of you. All the evidences are in front of you. Please decide this matter. That's the only request. So this is so far as the update on Gyanvyapi is concerned. The second issue is about Krishna Janmabhoomi. In Krishna Janmabhoomi, very important developments have happened. Just like if you all remember that in Ram Mandir case, the original suit was filed in Faizabad court in 1950, the first case by Gopal Singh Visharad. And the matter lingered in the Faizabad civil court for 39 years, when in 1989, seeing the importance of this matter, the government had moved an application to the Allahabad High Court saying that please exercise your powers under section 24 of the CPC and transfer these cases to yourself for original trial. In the same manner, seeing the importance of Krishna Janmabhoomi, I had moved an application before the Allahabad High Court, and we said before the Allahabad High Court that when any diplomat, any dignitary from foreign country comes to our nation, the first thing which we gift him is Gita. And Yogeshwar Shri Krishna, who have given us the Gyan of Gita, this matter pertains to him. It's a very sensitive and important matter, and the original trial must happen by the Allahabad High Court. Accepting our demand, on 26th of May 2023, the Allahabad High Court has transferred all the cases of Sri Krishna Janmabhoomi to itself, and all the cases are going on before the Allahabad High Court. The very important development in Krishna Janmabhoomi has happened is that, as you all know, that a very important stage in civil suit is the stage of Order 7 Rule 11, which is known as the stage of maintainability. And the objections were raised by Shahi Idgah Masjid that this case cannot proceed because it should go before the Waqf Tribunal. It is barred by Section 85 of the Waqf Act 1995. It is barred by the Places of Worship Act 1991. It is barred by the Specific Relief Act. It is barred by Order 23 Rule 3A. And it is barred by the Law of Limitation. These were the 5 pleas which were raised before the Allahabad High Court by Shahi Idgah Masjid. Let me tell you, by a detailed judgment of 110 pages, Honorable Mr. Justice Mayank Kumar Jain of the Allahabad High Court has rejected the Order 7 Rule 11 application of Shahi Idgah Masjid and has held that this case is maintainable and it can be proceeded with. The trial is going on before the Honorable Allahabad High Court. The Honorable Allahabad High Court had also directed for survey of the Shahi Idgah Masjid by Advocate Commissioner, but that order has been stayed by the Honorable Supreme Court. Why I am telling all these things and bringing, it's actually, why I am here is that it's not a matter of giving any speech. It's my duty as a lawyer that whatever is happening in the court, I must inform all of you, because basically this is a representative suit. Just like in Ram Mandir case, the judge, all of us who are sitting here may not be parties in Ram Mandir case, but the judgment which has come in Ram Mandir case is binding on all of us, because it's a judgment under Order 1 Rule 8. And when any proceedings happen under Order 1 Rule 8, it binds the entire community. So therefore, it is very, very important for all of you to know that what is happening in these cases. So in Krishna Janmabhoomi case, the order of survey by the Advocate Commissioner was passed, which is the first step in cases of such nature, but that order is stayed by the Honorable Supreme Court and the matter is pending in the Honorable Supreme Court. The second order is of maintainability, which we have won before the Honorable Allahabad High Court. That order has also been challenged before the Honorable Supreme Court and matter is pending in the Honorable Supreme Court. So the best part is that in Krishna Janmabhoomi case, so far as 3-tier system or 4-tier system is concerned, we have reduced it. We are now before 2 courts, High Court, and the first appeal goes to the Supreme Court. But in Krishna Janmabhoomi case, I wanted to tell you a very important development has happened. We have found a very rare and crucial document of 1920, of 25th November 1920, of the then ASI under the Ancient Monuments Act 1904. And you will be surprised to know that in that document it has been written and it has been mentioned. And let me tell you, this is not an ASI of the present government or the RSS or the BJP. This is the ASI under the British rule. The ASI in its order on 25th of November 1920 has written in Krishna Janmabhoomi case that at this place there used to exist a temple. The temple has been demolished and the site is utilized as a mosque. So the demolition of temple at Katra Keshav Dev, which is 13.37 acres of land, need not be proved. It is already mentioned in the documents of the ASI. And let me tell you, the Shahi Idgah Masjid, as per this notification of 25th of November 1920 and as well as by the latest notification, is a protected monument under the earlier Act of 1904 as well as under the present Act of 1958. So the effect is, the moment any monument is a protected monument under the Ancient Monuments Act, it becomes the custodian of this property is the central government. That's the first takeaway. The second takeaway is that for ASI survey, no direction from the court is required. Under section 13 of the 1958, the central government itself can do survey and excavation of the premises in question, which is a protected monument. The third impact is that these cases are there is an exemption under the Places of Worship Act itself. And Places of Worship Act says that if in any case it's a protected monument, the act will not apply. So these are the very important legal developments when we have found this notification on 25th of November 1920. So in Krishna Janmabhoomi case, the matter is proceeding fast, but we are hopeful that it has to go in a more speedy manner. And for that, as a community also, we have to raise a demand for speedy justice so far as Krishna Janmabhoomi is concerned. The third very important issue is about all of you. I don't know whether you would have heard or not, but that's also a very important civilizational issue for all of us. It's a matter of Bhojshala. Bhojshala is a temple in Dhar, Madhya Pradesh, which was originally a temple of Ma Saraswati, Ma Vagdevi. In that premises in question, a very abrupt order was passed by the ASI on 7th of April 2003, wherein the ASI had directed the Hindus, and you will be shocked to know this, In Bhoshala complex, the Hindus were directed by the ASI wide order dated 7th of April 2003 that Hindus will offer worship there on every Tuesday, and in the same premises, the Muslims will offer namaz there. You would have never seen such an order in your life where a temple complex, in violation of the ASI Act 1958, has been made as a complex of secular activity. In same place you will offer namaz, in same place you will offer worship. So this order was challenged by us before the Indore High Court, before the Indore bench of Madhya Pradesh High Court. The Honorable Indore bench of Madhya Pradesh High Court, Honorable Mr. Justice Dharmadhikari, passed an order for ASI survey in this issue. The ASI has given a detailed report in our favor and has said that by no stretch of imagination this is a premise of a mosque, this is a premise of a Hindu temple, and there are a lot of signs and symbols of Hindu temple. So we are very close to victory so far as Bhoshala case is concerned. The Honorable Supreme Court has stayed the proceedings of the Indore High Court in Bhoshala case, but so far as legal research and documentation work is concerned, all the most important thing in all these cases is that what is the research, what is the proof, what are the documents. So far as those questions are concerned, we have covered all those questions. Now we are very near so far as the operative portion of judgment which has to come from the court and the final argument stage is concerned. That is an area which is being left in Bhoshala case. So these are the developments which are going on. And apart from that, let me tell you that me and my legal team, my senior Hari Shankar Jain, and all of us, we keep discussing with Shefali Didi also, we are very much committed so far as liberation of each and every temple is concerned. Till our last breath, we will fight one by one all the temples which have been occupied in the past. We will fight legal battles to get liberated all those temples through legal research. Now we are working on one temple in Vidisha in Madhya Pradesh. You all know that's a temple of Surya Bhagwan that has been declared as Waqf property. So for that we are contesting legal case. Our cases on Taj Mahal, Qutub Minar, Tile Wali Masjid are going on. Very important development on Kalki Avatar will be, I will update you very recently. The place where Kalki Avatar has to happen, that place also has been acquired by the peaceful community. So for that also we are heading towards a legal battle. So these are the developments so far as these issues are concerned, so far as civilizational disputes are concerned. But I wanted to highlight today before you something which is very, very crucial and which I believe through my legal career has become a fault line of our entire community and this entire constitutional framework. From past few days I am reading this book, and I would suggest all of you to read this book. It's really you can say an eye-opener for all of us. The name of the book is Ambedkar's Thought on Pakistan. You must read this book. Now, if I will not waste the time as to what are the contents of the book, but when I read that book and when I see myself standing in today's era, I feel that we are standing in the same era, our country is in the same era, and the same controversies are arising in front of us which used to arise 100 years back. Nothing has changed. Same debate, same issue about a peaceful community. Now the point is this: our country was divided on the basis of religion. But despite that, if you will read the entire constitutional debates, Constitutional Assembly debates, there were words which were introduced as the word which is known as secularism. In the constitution, it was proposed by Professor K.T. Shah 3 times, and I have the records of that. 3 times this word secularism was rejected by the Constitution Assembly. Despite that, by way of 42nd Amendment, in our preamble, this word secularism and socialism has been added. Now the irony is, see how a bad how bad a legislative thinking can be, how bad a legislative drafting can be. How you, if you would have read the preamble before the amendment, it used to read like this: we the people of India, having solemnly resolved to constitute India into a sovereign democratic republic, and at the end it is written that we on this 26th day of November 1949 do hereby adopt, enact, and give to ourselves this constitution. So the preamble was a preamble which was an oath which was taken on 26th November 1949. How can this oath be amended after 26 years? And two words can be added that, all right, we forgot what happened 26 years back, so we are adding two words. So two words were added abruptly without any discussion when the entire country was in emergency. And the words were secularism and socialism, which were specifically rejected by the Constitution Assembly 3 times. And Mr. Ambedkar's speech is there that why these words must be rejected. Now the irony is this. Is the time is over? 5 more minutes. Okay, sorry. Just finishing. So now the irony is this. Now we have the word, and I'm telling you this dichotomy right in front of us. Now these words, socialism and secularism, are there in the Constitution. The judgments of Supreme Court have come in Bomai's case, in Keshavananda Bharati case, saying that secularism is the basic structure of the Constitution. But the irony is that you will be shocked to know that what is the meaning of secularism, we don't know. Secularism is the word which has not been defined. So the irony is this, that you have minority rights under Article 29 and 30. You have a mandate for a majority community under Article 28. So far as educational institutions are concerned, you are seeing the acts of the government while giving Hajj subsidy, while bringing Places of Worship Act, while bringing the Waqf Act, while bringing the Sachar Committee, while making minority appeasement politics. And whenever you challenge it in the court of law, the argument is that it is a part of secularism of this country. This is the irony. I have challenged this word, socialism and secularism, before the Honorable Supreme Court, and I'm hopeful that these words will be struck down. But apart from that, the other area which we have to focus, and I will end my topic today, are the issues of judgments. There are many judgments passed by the Honorable Supreme Court which are erroneous. And one such judgment, you will be shocked to know, I wanted to highlight it, is the judgment of TMA Pai given by 11-judge bench of the Supreme Court. And it was on the issue of minority. Now in that judgment, the Honorable Supreme Court has held that minority will be defined state-wise, and whoever is less than 50% will be minority. Now we all have to do a community thinking, we all have to do a collective thinking, and my idea is that we have to bring down this bracket of minority, and whoever is less than 5% or 2% or 3% only must be deemed as minority. The second majority cannot be termed as minority. So this is the fallacy in the judgment of TMA Pai, and you will be shocked to know that 11-judge bench gave a judgment in TMA Pai, and no one was able to understand the verdict. I'm telling you with a lot of sense of responsibility. So there was a total chaos and confusion in the court. In the first time in Indian legal history, 6 judges sat to explain what the 11 judges have said. There is the first para you read of P.A. Namdar. And the para of P.A. Namdar is, before the ink on the opinion of TMA Pai were yet to dry, these courts were flooded with several litigations to understand the ratio of TMA Pai. So then the P.A. Namdar clarified the ratio of TMA Pai. So TMA Pai read with P.A. Namdar is a very draconian judgment. We all have to fight against it. And this bracket of 50% minority category has to reduce. Minority means a minority which is less than 5% or 2%. The second largest majority cannot be termed as minority. And all the schemes of the central government which are going on for a particular community must be stopped. It is in utter violation of Article 27. There are many other topics which I had to touch, but definitely time is a constraint. I am very, very grateful and thankful to Shefali Tai, Jagannath ji, Western Ghats Literary Festival, and all of you for coming here in large numbers. And it's very, very great to meet all of you after so long and interact with all of you. Thank you so much.